When I draft or even review contracts, I have to read them multiple times, and I read them from a different perspective each time I read it again. So today, I want to share with you 9 points that I look for in every single contract that I read. Let's go ahead and jump right into it.
My faith rising. I'm crawling out the trenches, holding me. My life is...
Hello visionaries, welcome back to my channel. My name is Marisa Talbert. I am the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. So I've been gone for quite a while because I have just been so busy. I've had a couple of trials that have kind of just kept me from being able to record, but I thank you so much for continuing to subscribe, continuing to leave comments, and continuing to watch and share the videos. When I posted my last video, we had not even reached 5,000 subscribers, and now we've crossed over the 6,000 subscriber mark. So I thank you so much for continuing to take this journey with Talbert Law Office, and I hope that you're learning something in the process. With that being said, you all have heard me preach time and time again about ensuring that you have the proper contracts in your business transactions. And equally important is making sure that you know how to read and understand those written agreements that you enter into on a daily basis. Whether you're renting a car or applying for a new credit card or ordering supplies from a new vendor, all of these are contracts that you enter into regularly on a daily basis, and you need to understand those terms that you are obligated to or that the other party is obligated to perform for you. When I draft or even review contracts, I have to read them multiple times, and I read them from a different perspective each time I read it again. So today, I want to share with you 9 points that I look for in every single contract that I read. Let's go ahead and jump right into it. Number 1 is mutuality. Does the contract contain mutually beneficial provisions that serve both parties, or does the contract unfairly favor one party over another? When you're reading and reviewing your own contracts, you may want to create a list of which provisions impose a burden exclusively on you, create an obligation solely for the other party, or impose some type of burden for both parties. For example, you may have a contract provision that states the other party may terminate the agreement with a 30 days notice. This type of provision favors the other party, but leaves no option for you to terminate the agreement if you're unhappy. Alternatively, the provision could state that either party may terminate with a 30 days notice, which is a mutually beneficial contract term. You following me? So again, number 1 is mutuality. Number 2 is favorability. Favorability is related to mutuality, but when I'm reviewing contracts, I am looking to make sure that there are some favorable terms specifically for my client. Of course, depending on what the agreement is being used for. For example, if my client is licensing or renting out their intellectual property, I want to make sure that the contract has a provision that whoever is renting that intellectual property from my client, it can't be transferred or sublicensed. On the other hand, if I am reviewing a licensing agreement where my client is renting someone else's intellectual property, then I may want to make sure that the license can be used worldwide and isn't limited to a specific geographical area. All right, you got it? Number 3 is omissions. So I'm looking at what is missing from this contract. Does the contract state how each party can terminate the contract if they're dissatisfied with the relationship between the parties? Or does the contract have a provision which states which laws govern this contract if there's a dispute between the parties? There are things that you look for after you've reviewed enough contracts, and you can tell when something's missing, and so that's what I'm looking for with omissions. Number 4 is clarity. Can a provision in the contract be stated more clearly or directly? When I'm drafting or reviewing contracts, I try to minimize how much I write in legalese, and I try to write in plain English. So for those who don't know, legalese is basically like the technical language of the law. With legalese, you see a bunch of wherewiths and whosoever's and hereunto and hereby. And there's a place for that in contract law. The reason that many lawyers use the formal legalese type of language in contracts is because that language has already been tested by the courts, which means that as a lawyer, we can look to the case law and see how a particular string of words or a particular paragraph has already been interpreted by the court to favor our client or a particular party. But if we can rewrite some of those very formal provisions into plain English to be more clear, more efficient, and more direct, then that's something that I definitely strive for when I am reviewing contracts. So instead of writing something like, in witness whereof these parties hereunto have set their hands to these present as a deed on the day, month, year, herein before mentioned, right? I would just write, this agreement is entered into and executed on the day that it is signed by the last party. All right, moving right along. Number 5 is practicality. How practical or burdensome are the obligations of each party? Another way to look at practicality is how easy is it for a party to breach this contract? For example, let's say that you enter into a contract with a website designer who's going to completely build an interactive 10-page website for you, and they promise to do so in 2 days. That's generally unrealistic. It doesn't benefit either party for a breach to occur in this situation, and so maybe we would amend that provision to state that it will take 2 weeks to build the website instead of 2 days. And maybe those 2 weeks don't include holidays, something to that effect. So practicality is looking at, does it make sense in real life? Number 6, cohesion. Do the provisions of the contract conflict with each other, or is there harmony throughout the entire agreement? For example, let's say that you have a commercial lease, and in paragraph 3, the lease states that it cannot be subleased or assigned to another person. And then in paragraph 10, the lease states that if you want to sublease to another person, that person is subject to a credit approval by the landlord. Those conflict. So I'm looking for provisions that conflict within the contract so that they don't cause issues later. Just makes sense, right? Number 7, I'm looking at the longevity of the terms. Can this contract stand the test of time? Will this contract make sense a year from now, 10 years from now, or even 99 years from now if we wanted it to? So we've seen how this is commonly played out with technological advancements in the art, film, and music industries. A particular instance is how artists are paid for their copyrighted music. As we move from mediums such as vinyl records to tapes to CDs to streaming and digital downloads, some contracts have not been able to withstand the test of time, and artists have gotten cut short out of the money that they deserve because the contract did not hold up for these different types of mediums and changing of these technological advancements. However, we can draft contracts to withstand the test of time. And that's why having a good lawyer to draft a contract or review a contract for you is so important. Number 8 is enforceability. Will this contract hold up in court? What happens if the law changes? Are there illegal provisions in your contract, such as a non-compete clause? So not only are we looking at, can this contract stand the test of time, but can it hold up in court? And those two go hand in hand. And number 9, last but not least, we're looking at what are the available remedies to each party, particularly I'm looking at what are the available remedies to my client. If everything in this contract goes wrong, what are my client's rights and what can they do about it? In business transactions, businesses that are well situated or just serious about their business are generally and almost always trying to limit their liability, which means if their liability is limited, then it limits your rights if they breach the contract or if they don't hold up their end of the bargain in some way. Unfortunately, most people are too eager to realize they don't have any recourse until it's too late or until they're thousands of dollars into a situation that they're not benefiting from. If this scares you a little bit, then good. I hope it scares you into doing something about it. If you're ready to set a professional tone for your business, then you can head on over and get your contracts at the TLO Marketplace. If you're not really sure about what contract you need, take the 2-minute quiz that I've linked down in the description box below, and it will help you identify the perfect contract that you need for your business transactions. You only need to purchase it once, and you get to use it time and time and time again. And don't forget, it comes with a user guide that explains the contract, explains how to use it, and explains all the provisions inside. For the next 30 days, you can use the code TLO2024 and get a 15% off discount. So head over, grab your contract, and level up your business today. If you got to this point in the video, thank you so much for watching. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. And I'll see you in the next video. Bye.